Thank you, Mr. Chairman, Ranking Member Bishop, and members of the committee for this opportunity to testify before you today. On behalf of the Western Governors Association and Western States Water Council, a couple of nonpartisan organizations, independent organizations representing the governors of 19 Western states, I serve as chairman of the Water Quality Committee on the Western States Water Council, and appreciate this opportunity to discuss concerns regarding the Clean Water Act, Waters of the U.S. proposed rule by EPA and the Corps of Engineers. First, we recognize that the EPA and Corps of Engineers actions have significant effect on states, not just in the West, but across the United States. Therefore, it's extremely important that states be regarded as full and equal partners, in fact, as co-regulators under the Clean Water Act, as Congress intended for both the states and EPA to implement the Clean Water Act in partnership, delegating much of the authority to states to administer those laws as they see fit within their respective states. And in this particular case, the Western states at least are unanimous in their concern for the fact that the states were not adequately consulted in advance of this rule being proposed. While there were communications, status reports, so forth, as co-regulators and the ones that will be faced with much of the burden and cost of implementing what happens to waters of the U.S. Across the United States, not being involved in that rulemaking process and actually drafting the rule is of great concern to the states, and of course has led to much confusion here on the back end of the rulemaking process. As we noted repeatedly in our letters from the Western States Water Council, waiting until the public comment period to solicit state input does not allow for meaningful consideration of states' views as well as alternative ways the states may have for meeting federal objectives under the Clean Water Act. We also urge the agencies to recognize the federalism implications of this particular rulemaking, particularly noting Executive Order 13132 that requires a higher level of consultation with states where federalism implications do impact the states. And in fact, in the preamble to this rule, the EPA and Corps of Engineers say, I quote, this rule will not have its substantial direct effect on the states, on the relationship between the national government and the states, or on the distribution of power and responsibilities among the various levels of government. Of course, nothing could be further from the truth, because the very goal of this rule is to define where federal jurisdiction stops and where state jurisdiction begins. Nothing could have more of a direct and substantial impact on the balance of power between the federal government and the states. We reiterate what Governors Hickenlooper of Colorado and Sandoval of Nevada, as chairman and vice chairman of the WGA, said in their March 25th letter, that the agencies should consult with the states individually and through the Western Governors Association in advance of any further action on this rulemaking, and would also reiterate concerns that the Science Advisory Board that is set up under EPA to help advise this rule does not have state representation, yet there is a great deal of state expertise when it comes to these matters. 27 experts on that panel, and not one is a state agency scientist or expert. Finally, let me just jump to my Oklahoma-specific testimony with the very little remaining time that I have left, and say that on behalf of the state of Oklahoma, and not necessarily Western Governors Association and Western States Water Council, I reiterate the concerns about co-regulators not being just stakeholders, but in fact should have been involved in the rulemaking up front. Would also reiterate concerns about getting the cart before the horse in terms of not waiting for the connectivity report to be finalized, which can have a significant scientific effect on, I think, informing this rulemaking. And so it's encouraging to hear some of the words that were expressed today that this will not be finalized until then, and yet it's a mystery to me why you would even propose a rule without having the full vetting of that scientific report that should weigh so heavily on this rulemaking process. And lastly, a point that's been made in front of panel one, I think, over and over again, ambiguity. The point of this rulemaking is to ensure some clarity, which is very important for the states that have to implement the Clean Water Act rules. And yet, in our view, at least in the state of Oklahoma, we believe that EPA and the Corps of Engineers have simply taken an already fuzzy line of jurisdiction and simply moved it in a different direction, but it's no less fuzzy than it was before. Certainly defeats the purpose, I think, of this rulemaking process. So we look forward to trying to inform and provide additional constructive recommendations going forward that will hopefully clarify instead of make these decisions more ambiguous. But at the same time, we think it takes more than a couple of 90-day extensions to the comment period in order for the states to be able to engage in a very meaningful and constructive process of informing this rulemaking. Instead, we think what we need is more like a timeout and going back to the drawing board when the train's off the tracks. That's really the only way to get it back on, in our view. So with that, I appreciate the opportunity.
Thank you.